This is part B of the topic 2 lecture presentation in administrative law, merits review and administrative tribunals. In part 8 we looked at overarching concepts concerning administrative tribunals generally, merits review tribunals generally, and we looked at several of the civil and administrative tribunals at state and territory levels. In particular, we looked at Victoria, South Australia and the Northern Territory. In part B, we zero in on the archetypal administrative tribunal or merits review tribunal, the Commonwealth Administrative Appeals Tribunal. Right, as you can see, the Administrative Appeals Tribunal was enacted by the Administrative Appeals Tribunal Act of 1975. So it was actually inaugurated in a very late period of the Whitlam government, following on from the Bland and Kerr reviews that recommended all 4 parts of the so-called new administrative review package. And the rest of that package, Ombudsman, ADJR and Freedom of Information, was later enacted by the Fraser Liberal government, carrying on from the Labor government. So there was very much a bipartisan conviction that there was a need for major reform in administrative law, for giving citizens a major right to review, accountability, transparency in relation to government decisions that affected them adversely. Now, it's important to note the concepts of internal review and external review. Generally speaking, nearly every government decision that is reviewable by the AAT will have a right to internal review within the department or agency that was charged with making the original decision. Now we'll see a specific example of that when we get to the next slide. And generally speaking, you are expected, or your client is expected, to take advantage of that right to internal review by a more senior officer in the decision-making department before they're allowed to proceed to external review by the AAT or any other independent external merits review body. If your client hasn't availed themselves of internal review and they try to make an application to the Administrative Appeals Tribunal, generally speaking, the review application will be dismissed immediately. External review, as I say, is what the AAT does. And it's also, of course, what the state and territory civil and administrative tribunals do. And there's a very good reason, and this was spelled out by the Kerr and Bland reviews and acknowledged by the politicians of the day. There's a very good reason to have external, independent, impartial review, because even assuming, as we ought properly to do, that the department's decision is regular and lawful, and they've done the best they can, and almost always they have. Nevertheless, it can happen that the department has adopted, for instance, a policy to guide its deliberations. And it may be that there are new or exceptional circumstances in your client's case that the existing policy just doesn't accommodate, and the department has failed to be flexible enough to recognise that. It can happen over a period of time that the department or agency, they're doing thousands of these every week, they develop something of a process approach, tick the boxes, and they may adopt a tunnel vision approach and say, oh yeah, we've seen all these before, you know, yours doesn't fit in the box, bad luck, case dismissed. Whereas in fact, bringing fresh, impartial eyes to view on it might result in the impartial review saying, well, hang on, this case has merits and it's not inconsistent with the overall policy. It's just, you've adopted this tunnel vision approach and you haven't made the correct and preferable decision. So that's why there is a good reason for external impartial review by a body like the AAT. Now, the next concept you need to have some understanding of is that of first and second tier review. Now, up until 2015, the AAT generally functioned as a second tier external review body because there were first tier external review bodies before you got there. So it used to be the case that you had to do an internal review within the department, then a first tier external review. So for instance, if you were appealing from a Social Security decision, there was a first tier external impartial tribunal called the Social Security Appeals Tribunal. And you had to go there before you went to the AAT if you were still aggrieved after the decision of the Social Security Appeals Tribunal. Now all that's changed to a very significant extent, and I'll get to that in a minute. The next dot point we need to emphasise is that the AAT is a general administrative review tribunal for the review of both the merits and the legality of a very wide range of Commonwealth decisions. Not just a few, but a very, very wide range of Commonwealth decisions. It reviews the merits in the sense that its job is to make the correct and preferable decision on the merits of a case, and its decision, generally speaking, substitutes for that of the original departmental decision maker. It also can, and indeed really must, form a view on the legality of the original decision. And if it finds that the decision was unlawful for one reason or another, it may make a decision that substitutes for the original decision. The next important point is that the right to merits review, and this applies both at Commonwealth and state level, is not universal. You only have unlike judicial review. I mean, in judicial review, you have at both federal and state levels a right to judicial review if an administrative decision maker has made an unlawful decision. That was an aspect of the common law prerogative that Australia inherited from Great Britain at the various times of settlement of each of the colonies. So there's a right to judicial review in all cases if you can identify unlawful conduct. On the other hand, merits review only exists if and to the extent that an individual act of Parliament confers such a right. Now, typically that will be the act that establishes the original decision-making power. So if it's Social Security, it'll probably be the Social Security Act. If it's migration and refugees, it'll be the Migration Act, and so it goes. You will expect to find a right to merits review in those acts, and if you don't, there is no merits review. Now you should have a look at section 25 about that, and I'll say a bit more about that on the slide after next. Now, as I've already touched on in the dot point before last, the AAT used to function generally as a second tier review tribunal, and in some cases it still does, but since the 2015 reforms to the Act and to other legislation, the AAT now usually acts as both the first and the second tier review tribunal. In other words, there are divisions within the AAT, and there's a specialist division that does, say, Social Security appeals, but then if you're still aggrieved by that first tier AAT specialist tribunal, you can go on and appeal to the generalist larger AAT tribunal. We'll have a look at that on the next slide. The next thing that I mention is that the AAT is more legalistic than it was originally envisaged that it would be. The legislation enjoins it to be, speedy, expeditious, informal, etc. And to a significant extent it is, but nevertheless it still does look and feel and act very much like a court, with the AAT member up the front on the bench acting like a judge and refereeing the proceedings, usually, although not always, with litigants on both sides, who will usually but not always have lawyers, witnesses in a witness box who are sworn, and so it goes. Looks like a court, feels like a court, acts like a court. Nevertheless, it is still true to say that it's more informal, more speedy, more cheaper to a significant extent than a court, certainly much cheaper than the Supreme Court or the Federal Court. So it's usually a good place to advise your client to go before resorting to litigation before the Supreme Court or the Federal Court, because the AAT may rule in your client's favour, and therefore your client won't have to spend a fortune taking the matter to court. Now, as I mentioned on the last slide, the AAT nowadays, since 2015, mostly operates as a second-tier merits review tribunal, and I've taken as my example the structure in relation to merits review of Centrelink decisions. As the extract says, the AAT can review many decisions made by Centrelink, and there's a list of them there: social security, pensions, benefits and allowances, including New Start and Austudy and those sorts of assistance, family assistance and so on and so forth. Initially, as you can see, AAT functions as a first review tribunal. A first review, it says, is the first time we review a decision made by a Centrelink authorised review officer or subject matter expert. Now, that sentence encompasses two of the things that I've already said. Firstly, AAT can only review where there has already been an internal review within Centrelink, either by an authorised review officer or a subject matter expert. If your client has not sought internal review, you don't get to first base with a first review by the AAT. But if there has been an internal review and your client is still aggrieved, then they will in most cases have a right to a first review within the AAT, and the first review, as it says, is done in the Social Services and Child Support Division of the AAT. So in other words, the AAT now is divided into specialist subsections that undertake the first tier review, but then if you're still aggrieved after the first tier review, you're able to seek a second tier review of most decisions, and that's done in the general division of the AAT. Now, just pausing here, I've listed here some key sections of the AAT Act which I do suggest you peruse carefully for yourself. What I suggest is that you pause this video after I've given this little spiel, go to your PowerPoint slides and click on the links on this slide and go to each of the sections in turn and have a read of them for yourself. Section 25 defines the decisions that the AAT may review. It only really defines them by reference to saying, well, we've only got a right to do so. You've only got a right to do so if that right is conferred by another particular Act of Parliament. Persons who may apply, Section 27, essentially a person affected or aggrieved by the decision. So it's not just anybody. You have to be a person who's directly affected or aggrieved by the decision to have standing to challenge. Section 28 is a very important one that applies to all of the components of the administrative law package, both AAT and ADJR and FOI and Ombudsman, persons affected by a decision may obtain written reasons for decision. Now we'll look at, in a later lecture, what amounts to adequate reasons for decision, but that's an extremely important right. As we'll see when we get to judicial review, many of the grounds of judicial review really can't effectively be pursued unless you know the reasons and are able to establish the reasons why the original decision maker refused your application. If all they have to do is say license application refused or new start allowance refused or something, and they don't have to give reasons, it will be very difficult for you to get judicial review because, for instance, the judicial review decisions or grounds of review include that the decision maker took into account irrelevant considerations or failed to take into account relevant considerations that the Act required it to take into account, or acted for improper purposes. Right? Now, all of those are grounds for judicial review, but how are you going to prove what their purposes were? How are you going to prove what they took into account and what they didn't take into account if they're not obliged to give reasons? If all they have to do is Sphinx-like, if you will, say, application refused, bad luck, you lose. So Section 28 and the analogous provisions in the other elements of the administrative law package, ADJR, Ombudsman and FOI, are critically important aspects of allowing your client as an aggrieved citizen to hold the government to account, to get redress for an unfair decision. Section 28, critically important. Section 33, procedure of the tribunal, speedy, expeditious, inexpensive, etc. Section 39, opportunity to make submissions concerning evidence. Now, and again, another important one, especially with respect to natural justice, and I'll get onto particular aspects of that a little bit later in this presentation. Section 43, review by the tribunal itself. Now, that's accounted for by what we've looked at earlier with the two-tier system that now applies since 2015. Section 44, there is a right to appeal to the Federal Court of Australia from decisions of tribunal where there's an identifiable error of law that makes the decision unlawful. So you've got a number of opportunities. Your client has a number of opportunities to obtain justice if they are aggrieved or adversely affected by any or most government decisions. Firstly, internal review by the department or agency. Second, first tier external review, usually by a specialist division of the AAT. Thirdly, second tier external review by the general body of the AAT. And fourthly, if you're still aggrieved and you can identify a reviewable error of law, and we'll be dealing with that in the second half of the semester, then you have a right to appeal to the Federal Court from decisions of the tribunal. As I say, I suggest at this point you pause this video and go and have a look at each of these sections by clicking on the links in the slides that you'll find immediately under the video in the learning materials section. Now, I've already talked about the AAT's jurisdiction in the sense of stressing that it only has jurisdiction to review classes of decision that are vested in it by particular acts of Parliament, generally the Act of Parliament that gives the original decision-making power to a particular department or agency will also provide for merits review to the AAT. But if it doesn't, then there is no merits review to the AAT. But Since the AAT was implemented, as you saw in 1975, there have been attempts by departments and agencies who didn't want to be reviewed to try to persuade the courts that the jurisdiction should be regarded as even more limited than what you would have thought. Generally speaking, the AAT's jurisdiction is to review a decision. It's important, I'll get to this at the end of the lecture. A decision means final decision. You can't review every single interim decision made along the way. Only the final and operative decision is reviewable under the AAT. Secondly, though, it has sometimes happened, especially in the early days of the AAT, you found some lawyers trying to think of arguments that would further restrict the ability of aggrieved citizens to review the decision of a department or agency, where they didn't want it to be reviewed, obviously. The first one is Collector of Customs New South Wales and Brian Lawler Automotive Limited in 1979. The Collector of Customs attempted to argue that the AAT had no jurisdiction to review his decision because his decision had been made beyond power, or at least that was what was being argued by Brian Lawler Automotive. And the Collector of Customs tried to argue that Section 25 of the Act only gave the AAT jurisdiction to review decisions, quotes, made in the exercise of powers conferred by, in this case, the Customs Act. And the Collector of Customs said, well, look, if they're trying to say that I acted beyond power, then you, the AAT, can't review that because you can only review decisions made in the exercise of powers conferred by the Act, and they're arguing that I acted beyond the powers conferred on me by the Act. So you, the AAT, can't review it. Well, the Federal Court rejected that, not surprisingly, made it clear that a decision was reviewable by the AAT and could be challenged without regard to any artificial distinction about whether it was legally valid in the first place and therefore might not be a decision in a technical sense. It was reviewable by the AAT if it was intended to be a decision, whether there was some legal deficiency or not, and the AAT could rule on that legal deficiency. And then, if the Collector of Customs thought the AAT was wrong, of course, the Collector of Customs could appeal that to the Federal Court and say, well, the AAT got it wrong on the law. I was acting within my power. So you can't truncate that process by saying, oh no, the AAT can't look at that. It can. The other thing that was tried in the very early stages in 1976 in Ree Adams and the Tax Agents Board was that the AAT can form its own views on questions of law. Now, you would think that ought to be self-evident, wouldn't you? Because no executive decision maker, and at the end of the day the AAT is an executive decision maker acting in a court-like atmosphere, it's impossible for any executive body to administer and enforce the law if it's not allowed to form a view on what the law means and how it should be enforced. Presumably what was trying to be argued, or what was trying to be argued in Ree Adams, was that because the AAT was a part of the executive government, not the judicature, that it couldn't rule on questions of law. Well, that's not what constitutional law says. If you hark back to cases like Huddett, Parker and Moorhead and so on that define what is judicial power, you'll remember that judicial power has been repeatedly held to be the power to make final, binding and authoritative decisions on the law relating to people's rights, duties and liabilities in relation to life, liberty and property. Now, the fact that only a court can make a final, binding and authoritative decision on questions of law does not mean that an executive body cannot make a ruling on a question of law and enforce that ruling. And as I say, it really has to. How could it administer and enforce the law if it couldn't form its own view on what the law means and how to enforce it? All Huddett, Parker and Moorhead and so on say is that only a court can make a final, binding and authoritative decision on questions of law. And so there has to be, for executive action to be valid, there has to be a right in a citizen to either appeal or seek judicial review before a Chapter 3 court in order for executive action to be valid, because otherwise, if there was no right of judicial review or appeal, the executive body would be acting in effect as a judicial body, because it would be making a final, binding and authoritative decision on the law. But the AAT, of course, does not do that, does it? There is a right of appeal to the federal court, and there is a right to judicial review of decisions of the AAT. So therefore, it is not exercising judicial power merely because it makes rulings on questions of law. Access to the AAT, or standing as it's sometimes called. It flows from what I said earlier, especially from, say, Section 27 and so on, that you have standing to seek review in the AAT if you are a person who is aggrieved or affected by the decision. But what does aggrieved or affected mean? Well, Recontrol Investments in the Australian Broadcasting Tribunal throws some light on that. It was an attempt by various parties to seek merits review from the Australian Broadcasting Tribunal of an application by the news group, the Murdoch Group, for approval of share acquisitions. I think it might have been when they bought the Herald and Weekly Times, but I'm not absolutely certain of that. Various community groups sought to join in the AAT review of the Murdoch Group's application for approval of the share acquisitions. And those groups included the federal and Victorian executives of the Labor Party, or members of it, and the state and federal branches themselves, an unincorporated association called Justice in Broadcasting, the Australian Journalists Association, and an incorporated body called the Rupert Public Interest Movement. Now, going through all of those, which of them do you think would have had standing in terms of being a person aggrieved or adversely affected by a decision to approve Murdoch's acquisition of the Herald and Weekly Times? Well, I'll tell you. Firstly, the ALP members and their state and federal branches were held to have standing. They were potentially affected. They were the main opposition party at the time. I mean, this was back when the Fraser government was in power. They were the main political opposition. They were clearly interested to a much greater extent than the general public. The Australian Journalists Association was certainly held to have standing because, of course, their members were employed by the various newspaper groups and so on, including the Murdoch Group, so they were affected. Now, the incorporated body called Justice in Broadcasting, you'd think they might not have had standing because, you know, the fact that they just called themselves Justice in Broadcasting doesn't mean that they are tangibly, directly affected or aggrieved by the decision. Merely having an interest or commitment, however passionate, in the subject matter doesn't make you an aggrieved or affected person. You have to be aggrieved or affected in some concrete manner. However, justice in broadcasting was held to have standing because they had been permitted to participate in the proceedings at first instance. They'd made a submission to the broadcasting tribunal, and that had been taken into account in making the decision, and so they had acquired standing by virtue of being permitted to participate and having their objections already taken into account. They were entitled to continue to prosecute them. On the other hand, the Rupert public interest movement did not have standing. It couldn't confer standing on itself merely by incorporating itself and adopting objects in its objects clause about public interest and broadcasting and media and so on. So that gives you some hint on what makes someone an aggrieved or interested party, having a sufficient interest or to have standing. Re-gay solidarity is another example where a gay man by the name of Bright couldn't get AAT review of a decision to deport him because he wasn't an Australian citizen, and at the time there was a provision of the Migration Act that denied standing to someone who wasn't an Australian citizen to object to this particular class of decision. So because Bright couldn't object himself, the Gay Solidarity Group sought to prosecute the case on his behalf. But Justice Gallop held that the Gay Solidarity Group didn't have a relevant interest, partly because it couldn't confer that on itself by its objects in its objects clause, and also because, rather more surprisingly, Justice Gallop held that there was no discrimination in the treatment of Bright because he was being deported for committing a serious crime, even though the serious crime was homosexual behaviour, and people didn't get deported for heterosexual behaviour. But in those days, at least, anti-discrimination principles relating to LGBTQI people weren't taken with the same degree of seriousness that they are today. There would have been a huge uproar today from a decision like that by Gallop, I would have thought, but in those days it seemed like it was no particularly big deal. In any event, I guess re-gay solidarity is a little bit of a sort of an archaic artefact, but again it does give you some hints about, you shouldn't simply take for granted that your client will necessarily have standing to seek review in the AAT. It's something you do have to look at carefully. The role of policy as a consideration in AAT review is one that comes up frequently, and I touched on that in part A of this lecture presentation. I'm touching on it again here, specifically in light of case law in the AAT. Now, the critical cases here are Drake and the Minister for Immigration and Ethnic Affairs, both number 1 and number 2. So I'll focus mostly on those. It was the Drake number 2 is the probably the key decision to understand and quote in relation to the role of policy in merits review tribunals. And Justice Brennan, as he then was, of course he later became the Chief Justice of the High Court, but he was also the first President of the AAT. Justice Brennan held in Drake's case that having a guiding policy to guide the deliberations and decisions of any department or agency is not only permissible but desirable in the interest of promoting administrative consistency and fairness. He went on to say that it was appropriate for the AAT itself, on merits review, generally speaking, to apply such a policy, albeit not to regard itself as bound to do so, but to do so unless a clear reason was shown on the evidence why it ought not to apply that policy. Justice Brennan also gave an eloquent discourse on the distinction between the judicial and executive function and the need to keep that distinction clearly in mind. Although the tribunal could not deprive itself of its freedom to give no weight to a minister's policy in a particular case, if it regarded that policy as being unfair and not properly applicable in that particular case in reaching the correct and preferable decision, nevertheless there are substantial reasons that favour only cautious and sparing departures from ministerial policy, particularly if Parliament had scrutinised and approved that policy. If the tribunal, in reviewing a decision made in pursuit of a lawful administrative policy, consciously departed from that policy lightly, it would nullify not only the policy made by the repository of the discretionary power, but also any mechanism or surveillance that the relevant statute permits or provides. And of course it undermines the whole notion of responsible and representative government, which is one of the major underpinnings of a Westminster constitutional system. Now, in addition to Drake, the only case that I'll highlight specifically, you'll see that all of the ones I list on this screen, I summarise in the study guide. I'll only touch on one of them here, Re Aston and the Secretary Department of Primary Industry. That was a case concerning fishing licence quotas in the southern bluefin tuna fishery. And the fishing licence quotas were designed to reduce the effects of overfishing, so there was a substantial incentives verging on compulsion for people to surrender or sell their licence in order to reduce the pressure on the fishery. An aggrieved licensee challenged the quota scheme in the AAT, claiming that it was unfair and discriminatory and that its effect of reducing the quota of tuna that he was allowed to catch, its effect would be to send the licensee broke. Nevertheless, and it wasn't disputed that that might well be the case. So in terms of if the correct and preferable decision was just the individual justice to that individual fisherman, you would say, oh, this is unfair. The correct and preferable decision is to cancel the quota. But Justice Davies held that government policy in this case was appropriate and adapted to its purpose and proceeded to apply it. It might work individual injustice on the applicants, but the broader public interest in proper management of the fishery had to be given greater weight. Moreover, the fact that the policy had been arrived at after extensive consultation with industry was also given quite a lot of weight by Davies. And in addition, making an exception for the Astons would be unfair to all the other fishermen who had already been forced out of the industry by having a reduced quota, because that was the intended effect of the policy. So being fair to the Astons would be being unfair to everybody else. So I think the Re Aston case is a very good example of the interplay between individual justice and the broad public interest and so on, consistency and so on, that the AAT is obliged to balance. It can't unduly favour one over the other, but certainly good administration is the overriding attribute that needs to be kept in mind. in all cases. Procedure and evidence. This is a very important one. I enjoin you to read the study guide in relation to this. I'll just whip through the slide because there's a lot of information on it. I'd suggest you pause the slide here and read these sections, both in the study guide and focus more closely on the slide. The tribunal's independent duty to reach the correct or preferable decision on the merits, to stand in the shoes of the decision maker, and to balance between individualised justice and the public interest and the broader interest in consistency in terms of fairness. Consistency, not only a fair result for this individual applicant, but consistency across the board. The limited inquisitorial role of the tribunal. It doesn't just sit back and listen to what the parties choose to put before it. It may demand to be informed of other issues that the parties didn't choose to put before it. But as I've explained previously, it doesn't have the capacity to go out and investigate for itself in any very significant way. It doesn't have investigative resources like the Ombudsman or the Independent Commission Against Corruption. So an inquisitorial rather than just adversarial role, but a fairly limited one. And what goes with that, of course, is, as the third dot point says, the opportunity that a tribunal has during proceedings to draw attention of the parties to critical issues that may warrant further attention. And in a very pointed way, if the parties don't pay attention to those critical issues, they may find that they won't achieve a favourable result. The AAT has a special burden because it is bound by the rules of natural justice. It must give both parties a fair go, and it must not be biased or not act in a manner that might lead either of any of the parties to fear that there may be a reasonable apprehension of bias. So it certainly must act in an unbiased manner. It certainly must give a fair go to all of the parties. Fact-finding, is the tribunal a judicial or executive model? Well, the AAT is certainly a quasi-judicial model. There are other tribunals and where more often decisions will be made on the papers. Perhaps without there even being a hearing at all, an oral hearing with oral evidence and so on. The AAT, though, typically does have an oral hearing. There is the opportunity to call oral evidence. Fact-finding role of the courts. Of course, the courts are bound by the rules of evidence, and there is a formal burden of proof. You have to meet the burden of proof, whether it be beyond reasonable doubt in criminal matters or balance of probabilities in a civil matter. However, in executive decision making, including the AAT, even though it's quasi-judicial, there are no rules of evidence as such. It is possible for the AAT, and indeed this applies to the state civil and administrative tribunals, to allow hearsay evidence, to allow non-expert opinion evidence, and so on. And however, it's important to note that as long ago as 1933, in Queen and the War Pensions Entitlements Appeal Tribunal ex parte Bot, the High Court stated, and has repeatedly stated since then, that the rules of evidence are very important protections to finding a correct result that have been developed over hundreds of years, and they should be departed from only cautiously and for a very good reason, even by a tribunal that isn't bound by the rules of evidence. So a body like the AAT has quite a delicate task to perform. On the one hand, it's got to try and proceed in a manner that's speedy, expeditious, and not too expensive, and therefore reasonably informal. But on the other hand, it shouldn't lightly allow departure from the rules of evidence. It shouldn't just allow any Tom, Dick, or Harry to give hearsay evidence about stuff that they really don't know about but have just been told by somebody else, or to express a fearless opinion about some matter that requires some particular expertise. I mean, if you're not a doctor, your opinion on whether somebody's got cancer is probably not very useful. And so, generally speaking, you will not be permitted, even in the AAT, to give such evidence. The other thing is onus of proof. It is said that there's no such thing as a formal onus of proof in an administrative tribunal like the AAT. So it's neither balance of probabilities nor beyond reasonable doubt. What it said is that, and MacDonald and Sullivan are authorities for this, the ultimate task of a tribunal like the AAT is to decide whether, on the facts and evidence before it, the tribunal is, as it's sometimes put, comfortably satisfied or persuaded of the issues to be resolved one way or the other. Now, what does comfortably satisfied mean? Well, apparently it doesn't mean either balance of probabilities or beyond reasonable doubt. It means comfortably satisfied. But it's certainly the case, and Brigginshaw is the principal authority for this, that whether a tribunal is comfortably satisfied one way or the other will be very much influenced by how important the issues are before it. So if it's something that will directly affect somebody's career or livelihood, such as whether they're going to get their trading license renewed or something like that, then comfortable satisfaction will require a greater degree of evidence, a greater degree of satisfaction than if it's something relatively minor. Now, so the difficulty with all of this, I suppose, is that it's said not to be an onus or a burden of proof, but it sounds very much like it, doesn't it? How can you decide whether you're comfortably satisfied or persuaded without deciding how much evidence is needed for you to be comfortably satisfied or persuaded? And Brigginshaw essentially says, yes, that is what you have to do, and it'll take more evidence, more convincing evidence for you to be properly persuaded, where it's the consequences for the parties are very, very serious ones. And again, there's no doubt that the Brigginshaw onus, as it's sometimes called, does apply to administrative tribunals like the AAT, and that was held as recently as 2008 in Qantas Airways and Garma. So the weird thing about administrative tribunals like the AAT is supposedly there's not an onus of proof, and supposedly they're not bound by the rules of evidence, and that does import a degree of flexibility into the proceedings. But if you're acting for somebody before the AAT, you would be unwise simply to assume that you will be allowed to introduce hearsay evidence or non-expert opinion evidence, because you probably won't be. And you would be unwise to think that somehow or other you can put up a hopeless case and the tribunal will just toss a coin or something and might find in your favour. You should, in a practical sense, you should proceed as if you are going to have to satisfy something resembling a civil onus of proof at the very least, and that you've got more and better evidence than the other side has. The AAT and procedural fairness, I'm conscious of the time here, I'm not going to labour this point. I'll let you read the study guide on AAT and procedural fairness. Each of the cases listed here are important ones that you should read. Australian Postal Commission and Hayes I will just mention very briefly because it emphasises something that often people forget. Procedural fairness is not just there to protect the citizen applicant. It's also there to protect the government department or agency, the decision maker. The AAT, or indeed any administrative tribunal, is required to be fair to both parties, not just the applicant. Now, in Australian Postal Commission and Hayes, the Postal Commission successfully challenged in the Federal Court a ruling by the AAT that the Postal Commission was required to tender a video showing the applicant doing things that she claimed she couldn't do. It was basically the applicant, Hayes, was a Commonwealth employee, Postal Commission employee who had a Commonwealth workers' compensation claim, claiming, a bad back claim, basically, I think it was. And as often happens in workers' compensation cases, the Postal Commission had employed private detectives to sit outside her place with video cameras, and they'd managed to catch her doing things that she claimed she just couldn't do because she had a bad back, like carrying the garbage out every night, carrying the kids out on her back and throwing them around and things like that, which she really couldn't have done if she had the sort of back condition she claimed to have. The AAT ordered that she be allowed to watch the video before she gave evidence herself. The Postal Commission immediately appealed that to the Federal Court before that could happen, and the Federal Court ruled that although Section 39 required her, Mrs. Hayes, to have an opportunity to make submissions on all of the evidence, including the incriminating video, it didn't require that she see them up front, because that would be unfair to the Postal Commission. If she got to see the video before she gave her own evidence, she could tailor her evidence to what the video had caught her doing, and perhaps come up with some sort of excuse that explained away the inconsistency or something. So that would be unfair to the Postal Commission. An administrative tribunal has to be fair to both parties, not just to one of the parties. Application of the rules of evidence. I've already dealt with this on a previous slide, and so I won't deal with it again here. Please read the notes in the study guide about this, particularly about the Potchi cases and McDonald and the Director of Social Securities. They're both important cases that you need to know about. Lastly, I mention judicial review of AAT decisions. Remember, Section 44 gives a right to judicial review of an AAT decision if you can identify a judicially reviewable error of law. But what is a decision? A decision is you can seek judicial review of a decision of the AAT, but as I've mentioned previously earlier in this recording, decision has been repeatedly held to mean the final and operative decision, not every interim or interlocutory decision made along the way by the AAT, like a direction for something or other. It means the final and operative decision. Now that's been held by the important cases Director General of Social Security and Cheney, and Australian Broadcasting Tribunal and Bond. So, you can't waltz off and seek judicial review in the middle of the proceedings just because you think the AAT has made a legal error. Generally speaking, you have to wait until the end of the case and then seek judicial review of the final and operative decision. Now, at that point, of course, if there have been errors of law made in relation to interlocutory rulings, you can seek review on the basis of those, but you've got to wait for the final and operative decision first. You can't just waltz off every time you think you've had a dud ruling, because that would, of course, advantage parties who had, as they say, long pockets. The department or agency or a wealthy litigant would be in a much better position than somebody who wasn't. So that would of itself be unfair. So the rule that decision means final and operative decision is very much one that is in the interests of fairness. Right, you'll be pleased to know that that's your lot for this week. That's all you be getting on the AAT, apart from, of course, in the tutorial. Next week we'll be going on and looking at the next element of the administrative law package, namely the Ombudsman.